All right, it's 8:29. We can start if people are here. Is anybody here for Webb Roofing versus Edison Insurance, 19 CA 2590?
Yes, Judge. Good morning. Steve Carestes for the plaintiff.
All right, anybody here for defendant? All right, this is another motion to withdraw. Again, don't have a problem with it. Just if you would include the language, gives them 30 days and consequences of not obtaining new counsel.
Yes, ma'am. And does that 30-day stay, does it include court and discovery deadlines? Does it include an extension for that?
Yes, but it does not mean that I'm going to go through my docket and cancel all the hearings. So you guys have to take care of that.
Yes, of course.
Okay.
All right. Thanks, Judge. Have a great day.
Thanks, you too. All right, next case is, it's now officially 8:30. Francis versus Bradford Strayer and Lynn Strayer and Epicurean, I'm not sure what, 20 CA 27. Who's Mr. Larson, you here for that case?
I am here for the plaintiff, Your Honor. Good morning.
Good morning. All right, and who's here for the Strayers? Anybody? How about Epicurean Hoagies? I wasn't sure whether that was a typo or not. All right, this is a motion of extension of time to complete arbitration and remove the case from the trial docket. Mr. Larson, is this your motion?
It is not, Your Honor. It's the defendant's motion.
Huh. Okay. Well, they're not here. I'm looking at, it looks like you guys are set in the August docket. Do you have any problems with this?
I do not, Your Honor.
All right, so when do you guys think you're going to be ready for trial? Do you have any idea?
I'm ready now, Your Honor.
Oh, so we really need to know what they're doing. Okay, let me skip this and come back to it, and I'll be back with you. I'm just going to do one more case and I'll come back.
Yes, ma'am.
All right, next case is I'm going to do Borsenek versus St. John's Insurance, 20 CA 3714. This is a 15-minute hearing. You have three things, or at least, yeah, looks like three motions set for 15 minutes. So who's here for the plaintiff?
Good morning, Your Honor. Adrian Glazell here on behalf of the plaintiffs.
All right, who's here for defendant?
Mark Krzyzek on behalf of St. John's. Good morning, Your Honor.
Good morning. All right, this is a motion to compel deposition of defendant's corporate representative, plaintiff's motion to deem requests for admissions admitted, and defendant's motion for relief from admissions.
Well, we have good news for you, Your Honor. We were able to resolve all of the pending motions at the last minute, and we apologize for not being able to cancel on time.
Oh, that's okay. All right, so you guys just send me an order to my office email address in Word format, all right?
Perfect. Thank you, Judge.
We'll do so. Thank you, Your Honor.
Thank you. All right, so back to Francis versus Strayer. Nobody here for the defendant in that case? Well, then I don't know what to do. I can go to one more case. We'll see where that takes us and then come back. Okay, Amy Moore versus Estate of Basson, MD, 20 CA 652. Who's here for the plaintiff?
Yes, ma'am. Amy Moore.
Okay, who's here for defendant?
Good morning, Your Honor. Scott Sankey on behalf of both of the defendants, Dr. Bassine's estate and Neuroscience and Spine Associates.
All right, so I set this motion, or actually I think the defendant set the motion to strike and I set it by order. The plaintiff filed a motion which is legally insufficient and incorrect. So I'm assuming that's why the defendant filed a motion to strike, correct?
Yes, Your Honor. It's just a recitation of the allegations that are set forth in the complaint.
Right, and it's also asking to have a hearing to resolve all these issues, which of course we cannot do that. So here's the problem, Ms. Moore, you need to have an attorney.
Well, I filed, excuse me, ma'am, I filed that before I knew that we had a hearing set for the 19th. So I did not know that before I did that.
Okay, well, here's the problem. We don't resolve cases by hearings, okay? You're asking for a resolution of the ultimate issues of your case. We do that by a trial in front of a jury.
Yes, I understand that from last time. I wanted to do it in front of you, Judge, and the defendant denied that request, so I understand.
Okay, so I'm going to grant their motion to strike.
Yes, ma'am.
Your motion. So I'll
Yes,
need
ma'am.
an order from you, Mr. Sankey, sent
Yes,
to my
Your Honor.
office email address in Word format. Again, ma'am, I strongly advise you to get an attorney because I'm not allowed to help you in this trial. And there's a lot, and and for example, I strongly suspect Mr. Sankey at some point before the trial will file a motion for summary judgment. And if you don't know what you're doing in connection with those motions, you could have a result that you're not going to be happy with. So again, there's lots of attorneys across the state of Florida that do this kind of work. I strongly suggest you find one. All right, Mr. Sankey, I need an order from you sent to my office email address in Word format.
Will do, Your Honor.
All right, thank you.
Thank you.
Thank
Have a good
you.
day.
Yep. All right, let me go back to Francis versus Strick. Is anybody here for defendant? Going once, going twice, guess not. Okay, so, well, Mr. Larson, I don't know what to tell you. What do you want me to do?
Well, Your Honor, defendant failed to appear on their own motion to extend the time for non-binding arbitration. Since they failed to appear, I would request that the motion be denied.
All right, when is the deadline up? Let me just.
May 24th, I believe, Your Honor.
I sincerely doubt you're going to be able to get that done. Do you have it scheduled?
No, Your Honor.
Okay, well, you have to get it done before the trial. So what I'd be willing to do is move this case to September, just to accommodate that. Because what I'm going to do is when I go through my trial docket and I see that you guys haven't done your arbitration, I'm going to boot you off anyways. So if I put you in September, which isn't a very long continuance, and that docket's going to run from September 13th through October 15th. And the pretrial is August 2nd. That you need to have your arbitration done 35 days before that, which means it's going to be basically mid-June or the end of June. So if you'll get me an order continuing your trial to that September docket, we'll issue a new trial order and I'll extend the deadline to 35 days before that pretrial.
All right, if I understand correctly, I am to submit an order extending the trial docket to September 13th through October 15th. And upon your receipt of that, you'll issue a new pretrial case management order indicating that the non-binding arbitration will be done X number of days
No, you need to include in your order
before.
that the non-binding arbitration deadline is extended to 35 days before the new pretrial date, which was August 2nd.
Very good, Your Honor.
All right, thanks.
All right, thank you, Your Honor.
Yep. All right, next, last is Lazy Parrot versus TBC Dockside LLC 20 CA 4135. Who's here for the plaintiff?
Good morning, Your Honor. This is Attorney Chris O'Brien on behalf of the Lazy Parrot LLC.
All right, and who's here for defendant?
John Silverfield.
All right, so this is defendant's motion to dismiss plaintiff's complaint with prejudice. The problem is they filed an amended complaint after you filed your motion.
Yeah, yes, Your Honor, and I filed a motion to strike because it was improper to bringing in an additional defendant, which, as my motion makes clear, that requires legal court.
Okay, but the problem here is that this is just a waste of time. Okay, so I grant your motion, I give them leave to amend. They've already filed the amended complaint. I mean, so where are we? I mean, it's just, this is stupid.
But Your Honor, the fact is that we spent time going through and putting together the motion, which we think is meritorious, And basically all we're asking for is for this case to be dismissed so we can adjudicate it in the proper court, which is in front of the eviction court, in front of Judge Provost, where it's currently pending. That was the whole purpose of filing the motion to dismiss.
Okay, well, go ahead, argue your motion. But just so you know, the thing is, they don't, amazingly enough, which I found out in the last time I addressed this issue, they have the right to amend if you haven't filed an answer. So.
But they still need leave of court if they're gonna add a party, Your Honor.
That is true.
So that's why we're saying that obviously I understand the absolute right to amend. As you know, I think you're talking about the same case that I know about.
Yeah.
It's up on appeal right now. But at the same time, there's still procedural prohibitions if they do something additional. They're not simply filing an amended complaint with amended allegations. They're serving process on a new defendant. That requires leave of court.
Okay.
And therefore, that's why we're claiming that the amended complaint until they receive leave from you is moot, which allows us to argue our motion to dismiss. The underlying complaint.
Go ahead.
Okay. So basically, Your Honor, this entire case is a preemptive strike against the landlord's attempt to evict a holdover tenant under 8304.
Mhm.
I would like to point out that Mr. O'Brien sent me some cases that I'd like to distinguish before we get into the motion to dismiss itself. I think it's important. He's under the impression from some case law that he sent that 8304 is inapplicable to options to renew. However, we have a case called Painter versus Town of Groveland and another one called Trask versus Suskin. Both of them are talking about a still applicable 1909 Supreme Court case. One of them's from 1955, the other one's from 1967. Unfortunately, a lot of the law in this area is pretty old, but the Painter versus Town of Groveland Supreme Court case states, our statute, section 8304, provides that upon the expiration of a lease term created by an instrument in writing, if the tenant shall hold over in possession of the premises without reviewing the lease by some further instrument of writing, then such holdover shall be construed as a tenancy at sufferance. And then it goes on to say that the court in Brown versus Markham, that's the 1909 case, held that over a written, or sorry, I don't know why it says holding over under a written lease containing an option to renew, which is what's at issue, is, quote, subject to the provisions of 8304, and that in the absence of an instrument in writing extending the lease, the lessee was a tenant at sufferance. At most, the painters were tenants at will under the provisions of 8304, that if such holding over continued without written consent of the landlord, such tenancy shall become a tenancy at sufferance. So basically, all we're trying to do is evict a tenant that's holding over because we were unable to negotiate terms pursuant to a pretty clear option clause in the lease. Now, the causes of action that the lazy pair brings in this case are, one, for specific performance. As my motion clearly points out, courts are very hesitant, if not altogether prohibiting specific performance of a lease. And obviously, specific performance of any contract, lease or otherwise, requires definite terms. So that conflicts, asking for specific performance of the lease conflicts with the seeking of a declaratory relief, because they have to claim that there is some ambiguity within the contract. And here specifically, it has to do with the option provision.
Now, let me just tell you the confusion that I had in reviewing the file. I was confused as to when, because there was various options to renew, and I wasn't 100% sure from reviewing the documents attached to the complaint when, because there was also some other things executed when the lease term expired.
December 31st, 2020.
Okay. And there was an option to renew it, but they had to renegotiate the price, correct?
Yes, Your Honor. It had to be on the then prevailing rate.
Okay.
And we were unable to come to terms on that, which all the case law, and in fact, there's a really recent case, I did a notice of filing. Honestly, I didn't even know this case existed until I was preparing yesterday, from April 14th, 2021, out of the 3rd DCA. And it's talking about this Jahari versus 1830 North Bayshore. That's about the option provision being too indefinite when it comes to rent for it to be enforceable. This case was decided April 14th, 2021, says, quote, "The sole issue before us is whether the lower court properly awarded landlord immediate possession of the property following the expiration of the lease term." Same thing. While the expiration of the lease was not disputed, also true, tenant contends it was entitled to either renew the lease or purchase the property. Renewal is foreclosed by this court's recent opinion in Janahari versus 1830 North Bayshore. And then he says, quote, "The amount of rental is an essential element of a lease, if not the basis for the lease, and an agreement to make a lease or to renew or extend a lease that fails to specify either the amount of the rental or definite procedure to be followed to establish the amount of the rental is too indefinite to be legally binding and enforceable." And as my motion points out from the Janahari case, that's exactly the same facts as ours, where it was at the prevailing rate of rent. It was supposed to renew at the prevailing rate of rent, and the parties were unable to agree on what the prevailing rate of rent was, and therefore they were unable to execute a written renewal, and therefore the other party was a holdover tenant because they had no lease. So
okay, now my next question is, though we're here in a motion to dismiss.
Correct.
Those cases, were they decided on a motion to dismiss or a motion for summary judgment?
I don't know. I believe they were on a motion for summary judgment.
Yeah.
But Your Honor, that's different though, because the
So
fact
how
of
do
the
I
matter
know
is-
from just looking at this complaint that that there's actually no lease, essentially?
Well, I mean, I think it's undisputed that the lease expired by its own terms. If you look at the 3rd addendum, it states when the lease expires, and there's nothing
Right,
else.
but they've pled an option to renew, and so I'm just asking for the record. What are you pointing to in the complaint and any attachments that reflects that there isn't a lease and that they didn't come to terms, or they were required to come to terms and didn't come to terms in terms of the renewal?
Well, Your Honor, I was giving you background. That's really not my main crux of my argument. Honestly, The main crux of my argument is that these are all defenses or potentially counterclaims to an eviction action. You don't file something preemptively. Now, I get if you file a deck action prior to an insurance claim because you have claimants that are going to file suit. But on December 30th, 2020, we could have not filed for an eviction. We could have just let it go. We could have accepted their rent. So there was no controversy on December 30th, 2020. That's why all the cases that I cite regarding injunctive relief and regarding the deck actions are cases that say, hey, this isn't necessary. There's no irreparable harm. These are defenses that can be raised in an eviction action, because at the end of the day, what all they're looking for is to prevent us from evicting them, okay, and recognizing their option. So if we go in front of the county court, and try to evict them, which is what's currently pending, and the county court says, no, I don't interpret the lease that way. They're not a holdover tenant. You are not entitled to evict them. How is that any different than wasting the circuit court's time on a 5-count complaint, trying to prevent us from evicting them? It's the same outcome, except the other one is more expedient because it happens faster. The court adjudicates it more quickly. And frankly, at the end of the day, if there's a finding that we're wrong in the county court, then it is what it is. It's ridiculous to have a preemptive injunction, deck action, et cetera, when all the case law agrees with us that says that that's unnecessary and that these should be adjudicated in the county court. Not to mention, they filed this complaint as an attachment to their affirmative defenses in the county court case. So they agree that could be defenses in the county court. So all we're asking is that this case be disposed of and we can properly proceed in front of Judge Provost for the eviction. And if we lose the eviction because they exercise their option properly, then it is what it is.
All right, Mr. O'Brien.
Morning, Your Honor. I do like to point out regarding adding parties and seeking leave to amend, I do like to point out Florida Rule of Civil Procedure 1.250, subsection C, adding parties, states parties may be added once as a matter of course within the same time that pleadings may be amended under Rule 1.910A. I know council has filed a motion to strike. They have some case law cited where leave to amend was necessary. In those cases, there are concerns with the original defendants having judgments entered against them. There's also concerns with statutes of limitations. So the court did require a motion to leave to amend to add those parties. Here we have none of those considerations. So it's our position that Rule 1.190 and Rule 1.250 apply, and that our amended complaint is the operative pleading, and that we're here on a motion to dismiss a complaint that's been superseded by an amended complaint. Furthermore, addressing the case counsel cited, I believe was Jahari, those facts aren't identical. Here, our option states that the rental rate should be the reasonable market rate as determined by the landlord. So there is a procedure on determining that rate. It's to be reasonably determined by the landlord. And in our complaint, in the complaint, I have the complaint here because that's what's being dismissed here. In paragraph 15 and 16, 15 says defendant determined the fair market rate per annum base rent applicable to the extension to be $25 per square foot. Paragraph 16, plaintiff accepted defendant's determination of the fair market rate for the per annum base rent applicable to the extension to be $25 per square feet.
What's the case number for the eviction proceeding?
It's CC2, Your Honor. It's the second case filed in 2021.
What? Oh, so it's 21 CC2. Go ahead. All right, go ahead, Mr. O'Brien.
All right. Let me see here. So Your Honor, that doesn't apply, and I agree with Your Honor. This is on a motion to dismiss, and I believe we've sufficiently pled our causes of action. Your Honor, I did send over 3 very short cases over to counsel to support our position. If I may I please screen share each case is about a page to 2 pages long.
Sure, go ahead.
Let's see if I can figure this out. Can everyone see? It should be a PDF file. Dayland Shopping Center Inc. versus
Yep.
So this is a third DCA case, and it's very short. I have a highlight here. This is an appeal by the defendant below, which seeks to overturn a final judgment entered by the circuit court granting specific performance to the plaintiffs under a lease renewal option. And then they conclude that the court's construction of the renewal option provision was fair and reasonable and supported by the plain meaning contractual language, which is included here above. So courts do grant specific performance for leases for a renewal option. So the position that defendants taking that courts generally or perhaps never grant specific.
But what we don't know in this case, I can't really tell from, is whether or not there was a pending eviction proceeding.
No, the eviction was filed after, Your Honor.
That's correct.
Yeah.
Our lawsuit was filed before 2021. It was filed December 30th.
Okay.
And then regarding 83.04, we're not, Your Honor, we're not trying to circumvent 83.104. This case, Henry v. DSM Company states, the parties in this case are landlord and tenant. They entered a written lease agreement which granted the leasee appellee an option to renew the lease for additional 3 years. The lease did not specify the option should be exercised in a particular form. Both parties thought summary judgment procedure was appropriate, and then the appellate court ruled appellant's total reliance on section 83.04 statute is not justified in this case. Equitable considerations can vary the application of that statutory section. And here we have equitable considerations in that we did have a lease option, we exercised it, and defendant refuses to acknowledge us exercising and is seeking to evict us.
And Your Honor, that just further proves my point that.
Okay, he's not finished, Mr. He's not finished. I don't think.
And this is the last case I have to support that we sufficiently pled causes of action. This is DHS Corporation v. Affordable Enterprise Exchange. This is from the 4th DCA. An addendum to a commercial lease agreement contained an ambiguous renewal option provision. Its several parts in hopeless and irreconcilable conflict. The tenant sought a declaratory judgment of the parties' rights. The trial court determined under the principle of adverse construction that the right to exercise the option belonged to the tenant, and the non-drafted lease we affirm. So the courts do grant, do make decisions on declaratory relief regarding renewal options, on whether or not they're enforceable or.
Okay, but here's the thing. I'm not going to have two cases proceeding in two different courts. So, and as much as I just love having eviction proceedings in my court, nevertheless, it's got to go one direction or another. And so we're not going to have two cases where we could have disparate results. So.
And Your Honor, I would like to move to consolidate both cases. In the eviction case, we moved to dismiss, arguing that the eviction should be filed as, that's correct. Yeah. Should be filed as a compulsory counterclaim. That was denied, but Judge Provost did suggest that he felt like he would no longer have jurisdiction because I did allude that I was going to be consolidating both cases. And since
Mr. Silverfield, hold on, just let Mr. O'Brien finish.
And Your Honor, this current action was filed before the eviction. So if we were to consolidate, it should be consolidated into this case.
Well, yes and no. I mean, the eviction proceeding the county court has jurisdiction over the eviction proceeding. So I'm not sure that the lower case number issue kind of applies, but we'll see. Anything else, Mr. O'Brien?
And I just like to point out that if counsel is correct that we can't do a preliminary action, then we should, and all that should happen is a dismissal without prejudice, so we can refile in county, at which point would be moved back to circuit court as we have a right to be back where we started.
All right, Mr. Silverfield, go ahead.
Okay, just again, Your Honor, talking about 34-0112, exclusive jurisdiction of the county court over evictions. And obviously the other, and Mr. O'Brien made the point that I don't disagree that it should be dismissed probably without prejudice to file as I don't know, something in the county court action. I also don't disagree that if there are damages pled that are X, then there could be a potential motion to transfer. But these are all things that they knew about already, but they decided to file preemptively. Okay, they knew that they could do all these things and that this would be the outcome of this hearing, but that's not what happened. So all we were trying to do is try to get this to be proper procedure, which would be, okay, you want to file a counterclaim against somebody arising out of the same transaction and occurrence and is greater than the county court's jurisdiction, then you file a motion to transfer based on the amount in controversy. That happens all the time in eviction cases, as Your Honor knows. So all we're saying is, hey, that's fine. We can argue these points in the circuit court if it gets kicked up to that from Judge Provost. But it's not appropriate to have this as a preemptive case before the court when there's a pending eviction action that the court registry already has deposits in it, and we're not getting paid any rent. We're just trying to get this adjudicated. And it's, to me, a delay tactic, but I'll let Your Honor, we'll deal with that at a different.
Okay, I understand your procedural issues here. I hope. All right, so what I'm going to do is try to clean this up a little bit. number one, I agree with Mr. O'Brien in terms of his right to amend. As you've pointed out on appeal, I think that I may have been under a mistaken impression based on how we've done things for the last 35 years that you needed to request leave to amend, and I'm not sure you need to do that. So I'm going to deem his amended complaint filed as of today, number one. Number two, I'm going to consolidate these cases, and the eviction proceeding is going to be transferred to me. And now the thing that I don't know what to do with is, I understand your procedural issues here, which is, and I did not see an answer filed in the eviction case. Has an answer been filed, Mr. O'Brien?
Yes, Your Honor. It was a motion to dismiss, and in the alternative, it was an answer in affirmative defenses.
That's just
we're unsure if you filed a motion to
office.
dismiss
Hold on just a second. Let me just see. Okay, I see it now. Kathy, that needs to be retitled in the clerk's records, because it just looks like a motion to dismiss, and it is actually an answer in affirmative defenses. Okay, so I think we can proceed along in this manner, since they have pled those affirmative defenses in the eviction proceeding. So since they have asked for relief that's slightly different, and they did file earlier than the eviction proceeding, I'm not going to dismiss it, but I am going to consolidate it. I'm going to deem the amended complaint filed as of today. I'm going to give you 20 days to answer or otherwise respond to the amended complaint. So you can file another motion to dismiss if you want to. But I'm not going to dismiss their complaint and say that they can only plead these as affirmative defenses in the eviction proceeding. That doesn't make sense, Mr. Silverfield. They filed this earlier.
But Your Honor, I didn't say that it would be affirmative defense. I said it would be a counterclaim, which my point is that they should have waited until we actually filed, because this case, if we never filed the eviction. You can't tell them. Nobody can tell anybody how to file that. So I'm not going to reorganize how this was done. So what happens to our eviction complaint?
It's still there. We'll still proceed along with it.
So I have to respond to their complaint, amended complaint, within 20 days.
Yep.
Okay. So it's basically going to be our eviction case is a counterclaim to their.
The reason I'm consolidating it is that judicial economy does not like it when two judges are considering the same issues and coming to different results. So this gets it with one judge, and hopefully I will be consistent in terms of my rulings. So yes, I'm consolidating it because we don't want to have two judges making different rulings. Otherwise, you guys have a fine mess here, and feel free to try to figure it out. But I'm not going to tell Mr. O'Brien that he's not allowed to file until he certainly has he had a cause of action. You guys allegedly, weren't responding and weren't setting the rent pursuant to the lease renewal provisions. Okay. So now once you've sued him for eviction, now he has to refile. That doesn't make sense to me.
Okay. So Your Honor, I have a motion for judgment of possession that's pending before provost. So I can bring that immediately. Is in this case.
You can bring that in front of me. Yes.
Okay. Under the summary procedure,
so I'm going to need an order from somebody here to this effect. Mr. O'Brien, since this is essentially what you want, why don't you get me the order after you've circulated it to Mr. Silverfield, forward it to my office email address in Word format. You might want to get that to me soon. Anything you've got scheduled in front of Judge Provost, you need to cancel.
Your Honor, would the summary procedure apply?
Yes.
Okay. I need to make sure that's in the order, I believe.
And you're going to need to refresh my recollection about that procedure, because I don't do evictions very often.
No, it just means that we have expedited.
I know I've done these before. I'm just saying.
Okay, and then
Don't
there's
skip
money
on
in the
it.
court registry. What do we do with that money in the court registry in the order that requires them to continue to deposit it?
Everything that applies in eviction proceedings continues.
Okay, so that money from the court registry.
Have you
with
filed a motion to distribute the money?
I filed one, but there's still money in there. So
Okay,
do we
well,
need-
you need to take the appropriate procedural steps.
So the case is being eradicated, but it's being brought in. So wouldn't the money transfer from the court registry into this one and the obligations
Yes.
that are?
Yes.
Okay.
Yes. But are you, what we're really doing, well, it's up to you. Are you sure you want to do it that way? Because
I mean, unless they consent to the money being released, and then, but the continuing order that Judge Provost entered in that case says that it shall continue during the pendency of the eviction action.
right.
So
I'm not eradicating any of his orders.
okay.
Yeah.
But we can transfer what's in there to our client through a motion directed
Yes.
to you or to them.
To me. I'm
Okay.
now the judge in this case.
Okay.
I'll get that order to you, Your Honor, or I'll get it to counsel first.
That'd be fine. Thank you.
Thank you, gentlemen.
Your Honor,
Yep.
March 8th of 21, motion to dismiss, you want that to read answer to?
Yeah, that's what it's titled. It's defendant's motion to dismiss complaint, or alternatively, defendant's answers and affirmative defenses.
Okay,
So it needs to be titled so that, I don't care how they title it, but it has to reflect that there's an answer in there, not just a motion to dismiss.
okay.
All right.
Got it.
Thanks.
Thank you.
All right. That concludes the 8:30 docket. I'm not sure who Erwin's iPad is.
Your Honor, this is Erwin Gilbert. I have to start with an apology. We set a hearing this morning in William Francis versus Bradford Strayer et al., case number 2020.
I already dealt with that.
Judge, I hope at least you'll accept my apology. We had some incorrect information regarding the Zoom address.
Okay. What I did was I continued it to September. The pretrial date is August 2nd. And I ordered that the arbitration be completed 35 days, no later than 35 days before the pretrial date. If you want a more continuance than that, you're going to have to talk to Mr. Larson or get another motion in front of me.
Judge, we'll have to do that. They've increased the number of counts to 9. We have quite a bit of work in front of us. We'll do our best, but I will make a new motion.
Okay, good enough. Thank you, sir.
Judge, thank you.
Yep. All right, that concludes the 8:30 docket. We have a 1:30 and a 2 o'clock, Kathy.
Correct.
All righty.
All right, thanks.